week 7 of term 3, 2019-2020. Just some advance notice. Next week, which I believe is the 14th of January, I will not be available for the live session. I've got some work commitments in Brisbane. So what I propose to do later this week is to pre-record the session for week 8 and to upload that. So I do apologise, but of course the line will be available at this time. So it might be an opportunity for you to go online and talk about the unit, perhaps discuss in a collaborative manner the assessment regime, examination pieces, any of those sorts of things that you want to do in my absence. So please keep that in mind. If you have any questions arising from tonight's session, for those of you joining me live, and thank you very much for doing so, please unmute your microphone or use the chat facility. And of course, if you have any questions during the week in relation to this week's content or next week's content, please use the Q&A facility. So we have a lot to cover tonight, and as you probably have gleaned, much of the material for this week's reading and the contents of what we're going to cover tonight directly relates to the second assessment piece. We've had some excellent questions on the second assessment, and particularly in relation to the current status of the Townsville Port project. You've probably come to a view as to where it's at. I'll cover that briefly tonight, but if you find, there's a bit of a hint here, that there's not much to talk about in terms of its current status, I'd recommend that you provide some overview of historical status at various stages. So tonight we're talking about environmental impact assessment. And it occurred to me that while I have some material online from environmental scientist Phil Jeston, I do have 2 recorded sessions, I think one from 2014 and another from 2016, where I had Phil join me as a guest speaker. And I'll upload those through to Moodle, probably do that tonight or tomorrow. So please keep an eye out for that, because from a technical and practical perspective, what Phil has to say is very interesting and I'm sure very useful to you. Now, given that we're well into second year and for some of you third year of your university studies, I'm sure you're all well aware of the general need to present your material in a very professional manner and of course to cite your research. So I take it you're all aware of AGLC 4, and you should be able to cite your material in that regard. Some of the basics: make sure that you cite your material in footnote referencing, not in the body of the text, because we have some people, I think, enrolled in this unit that aren't part of the law school. So AGLC is different to Harvard referencing or some of the other forms of referencing. So use footnote referencing, not in the body of the text. Make sure that cases and to some degree legislation are named in italics, printed in italics. If you're referring to a case, it may be that you're referring to it essentially by volume or year. If you have a volume for the series, then the year of the case being decided is in round brackets. If it's a citation which is undertaken by reference to the year, we use square brackets. So it depends if there's a volume or not. Make sure, of course, you refer to the page of the case number, and if you're referring to a particular part of the case, please do pinpoint reference, and it's pretty simple. So, for example, Dietrich against the Crown, then 1992 in round brackets. Round brackets because in that instance there's a volume. The volume is 177. Then CLR, which is short for Commonwealth Law Reports, which is an authorised report, and the page number of that particular case, 292. If you're referring to a pinpoint reference, include the page number. For example, it might be that the citation is Dietrich against the Crown, round brackets, 1992, 177 CLR 292, 299, the last part to identify the pinpoint reference. And for those of you not trained previously in the law school, make sure that you reference a case or legislation by its appropriate citation rather than the URL to Austerley or to Legislation Queensland or JADE or whatever service you're using. So don't include the URL, include the actual citation. I know that's all pretty basic for many of you, and thank you for your patience. So tonight we're dealing with environmental impact assessment. And one of the themes for tonight is the way in which the environmental assessment regime comes about in a practical sense to reflect the cooperative nature of arrangements between the Commonwealth and the states. And you might recall that in the 80s, the states and the Commonwealth were having some very high-level litigation in the High Court in relation to environmental law and other things. And the Commonwealth was consistently winning that battle, which led to the COAG arrangements in 1992, as I recall, where essentially the states collectively pulled back in terms of the environmental law constitutional challenges. And as a result of that, we've seen a much more cooperative approach. So when it comes to the EIA-EIS regime, you'll see that there are cooperative arrangements between the Commonwealth and the state to avoid essentially duplication. The other theme of what we'll be talking about tonight is that environmental impact assessment should not be seen as a replacement for decision making. In other words, the assessment that is presented may be highly influential, but the report writer does not therefore dictate the decisions that is made. So the decision maker, whoever that might be, in the context of receiving an EIA or an EIS, will ultimately make a decision taking that into account, but it's not necessarily determinative of the final decision. So tonight we're talking about issues to do with project planning, and it may be that project planning involves putting together systems and procedures, and when it comes to planning and coordinating a large-scale project, for example, the environmental impact assessment process is critical. And I'm sure for those of you that have commenced your second assessment piece, you're probably well aware of how important that might be. So any questions at this stage? All good? All right, we'll continue, but if there are, just let me know. So have a look at your textbook for general description of what we mean by environmental assessment. We certainly know that it's an important component of decision making around environmental law issues. And it's very important to project planning, as I mentioned, and development applications. Now, I guess in a way, the purpose of an environmental assessment is quite simple. It's designed to ensure that information and assessment and analysis is undertaken in a systematic and comprehensive manner to enable decision makers, particularly regulators, to make informed and rational decisions. So that's what I mean, the distinction between the EIA or the EIS, which is generated as a result of the EIA, being presented so that the decision maker can make the best decision possible. So the environmental assessment is not the decision, but it's an important aspect in many ways for the decision to be made by the regulator typically. So what does it involve? Now, again, have a look at the videos and materials by Phil Jeston, but environmental assessment involves investigation, and it also involves, as the name would imply, an assessment. And the procedures that are adopted vary depending on the nature of the activity under consideration. Not every development project needs to have an environmental impact assessment. And the different types of projects, and to some degree the more important the project, the greater the extent of the environmental assessment that's required. So we need to consider some basic distinctions, and one of them is when we're talking about an assessment, we're typically doing so in relation to a development or an activity. And if we're talking about an activity, it may be that it's of a prescribed nature or prescribed class. So you'll see reference in the material to whether it's a prescribed activity or not. So just keep an eye out for those sorts of key words that I've talked about so far. It may be that the Minister has determined that there's a particular requirement for assessment in order to exercise a ministerial discretion. Or it may be that the Minister has determined that conditions are likely to have a significant impact. Again, another phrase that you see quite often in the context of environmental assessment. But what environmental impact assessment does not do, to follow on from an earlier comment, is it does not create a veto power into administrative decision making. In other words, it's not as though the report writer can cause something to be stopped as a result of recommendations. Decision makers need to take it into account when making a decision. One of the things that we've talked about this unit is ecologically sustainable development. And it kind of fits in with this EIA process in that the decision maker may have the benefit of the environmental impact assessment in making the right decision. But always, the decision maker will need to make a decision that is consistent with the principles of ecologically sustainable development. And you'll remember the definition of ESD is much further than just the environment. The decision maker certainly needs to take into account environmental considerations, but also social and economic considerations that might be inherent in a proposal. So when you're analysing a project, when you're analysing an environmental impact assessment, keep in mind that it's not just the environmental, but it's the social, the economic, the cultural, and other factors that need to be considered. All good? Thank you very much. I know I'm doing a lot of talking, but we have a lot to cover tonight. And again, if you have any questions, just stop me and we'll discuss it. Now, of course, what we've talked about so far is the general concept of environmental impact assessment and how it works, how it fits in to decision making to some degree. But let's talk about the process, and your second assignment piece gives you, I think, a pretty good idea of how the process works in practice. So there are a number of procedural steps typically involved in the making of an environmental impact assessment. We'll go through 6 of them. The first is that there is a referral. Number 1, a referral of an activity of potential environmental significance to a decision maker. So the referral is the first thing. Number 2 is the screening decision as to whether there's a need for an environmental impact statement based on whether the proposed activity is likely to significantly affect the environment. So the screening process, the threshold test. Number 3 is a scoping procedure to determine the range of matters that needs to be addressed in the EIS. And that'll be defined, and you would have seen that for the Townsville Port project. Number 4, consultation with relevant governments and with the public. Number 5, a review of the final EIS. And number 6 is monitoring the proposal if it requires some degree of accuracy of predictions and determination as to whether those predictions have been appropriately determined. So they're kind of the steps generally for determining the need for and the process of beginning the EIA, which results in the preparation and presentation of the EIS, the Environmental Impact Statement. Now, I'm going to attempt to share. I hope it works. I don't want to blow the system, but everything seems to be fine at my end as far as the internet is concerned. So we'll give it a go. And I'd encourage you to look at these materials that I'm providing online tonight with a view to bookmarking them and referring to them for your assessment work generally. So I'll start the share now, and I want to take you to the Australian Government Department of Environment and Energy, and you can call that up on your screens if you wish. So let's see if I can find it. Sorry, just a matter of ensuring that I get the right page here. Hopefully now, please let me know. Carolyn, can you see the Australian Government Department of Environment and Energy screen? Thank you.
Yep.
All right, thank you, I appreciate that. You'll see there that environment.gov.au EPB C/publications/environment-assessment-process-flowchart. And this is the federal government, of course, and the Department of Environment and Energy has a lot of very good material. And you'll see that I'm at the, I'm looking at EPBCA publications, and in particular, commentary in relation to environmental assessment process, the referrals, assessments, decisions flowchart. And the flowchart shows the referral stage of and the assessment decision-making process under the EPBCA. So it's in PDF. You'll see at the middle part of that screen that you can download that document, and it provides a very clear way of understanding the EPBCA Environment Assessment Process Referral Flowchart system. And if you follow this, it's much easier, I think, than trying to work it out by reference purely to the Act. So that, but I would read this flowchart in conjunction with the legislation. So you'll see, for example, that at the start, one of the threshold questions is to decide whether there needs to be a referral. And it's listed there. What are the questions that need to be asked if we're considering that question? And the starting one is the proposed action likely to have a significant impact on a matter of nationally environmental significance? So what I'd recommend is that when you look at this flowchart, you refer it back to the legislation and have some notes as to the definition of, for example, significant impact or national environmental significance, and be able to source where this commentary comes from in the legislation. Now, helpfully, the flowchart goes on to describe with some degree of particularity the matters of national environmental significance: World Heritage Properties, National Heritage Places, wetlands, which is Ramsar, threatened species and ecological communities, migratory species, Commonwealth Marine Parks, the Great Barrier Reef Marine Park, nuclear actions, water resource, and then other matters about proposed actions that have a significant impact on the environment, and some referrals that might be proposed by the Minister. So if you decide that the proposed action does not have to be referred, this is the developer or the proponent, then the matter does not need to go to the Minister for approval. But if it does need to go to the Minister for approval, then a series of further questions follow. Now, I won't go through this in detail, but I'll ask that you please study it. And you'll see there that a person proposing to take the action may make a referral to the Minister via the department. And there's a question there of whether the approval is required under the EPBCA and on the process of assessment, as opposed to the action being clearly unacceptable. It goes on to the second page, and you'll see there that there is reference to the accredited assessment process, the assessment referral information, whether the material needs to be assessed by an EIS, and whether it needs to be considered under a bilateral agreement, which is where we involve the states. So there's 2 pages there in relation to that flow chart. Hopefully you'll find that a useful document. Now at a state level, we have the Department of State Development, Manufacturing, Infrastructure and Planning website, and you'll see information there about the coordinated project process. Now the proponent, it says, of a coordinated project must prepare an environmental impact statement or an impact assessment report. So the terminology is slightly different at the state level. We're talking now about coordinated projects. And you'll see there the flowchart provides information about the preparation of the environmental impact statement, and you'll see that it's to be prepared in accordance with the terms of reference for the EIS. And when you're undertaking your work for the second assessment, you'll see that I've guided you towards the terms of reference for the EIS in that particular project. So they're the steps undertaken at a state level in relation to coordinated projects and the assessment process generally. You'll see that there's reference to the scope of the EIS as opposed to the scope of the impact assessment report, and you'll see that there's definitions in relation to environment. Now there is a need to consider advisory agencies which do review the drafts of the documents, and you'll note there that a coordinated project suspends those projects that are otherwise being assessed under the Planning Act or the Environmental Protection Act. So do have a look at that flowchart, and you may find that useful. I'll just stop the share there. Okay. So one of the things that you've probably picked up on is that an environmental impact assessment is not required in every instance. So given that fact, there isn't a question, a threshold question, about determining the need for an environmental impact assessment. And the obligation generally falls upon the proponent. So the one that's agitating for the project, whomever that might be. And the proponent has the obligation to refer a proposed activity to the relevant assessing authority to initially determine whether there's a need for an environmental impact assessment. Now, in Queensland, many EIAs are automatically triggered if there's a proposed activity of a certain type or it falls within a certain class. In that regard, have a look at the State Development and Public Works Organisation Act 1971, refer to sections 26 and 29. Coming back to the Commonwealth sphere, we've identified that the key piece of legislation is the EPBCA. And you'll find that the Commonwealth, like the states, have excellent materials in relation to this. I'll share the screen again so that we can consider the Environment Protection and Biodiversity Conservation Act Environment Assessment Manual. Now, this is something that you'll see that Chapter 4, it implements Chapter 4 of the EPBCA. And I'm not sure if I've uploaded this, but you should be able to find it quite easily, quite simply. This particular version was published in May 2012. Now, the reason I like this manual is that it's pretty much hands-on. And if you can follow the manual and then read the legislation, the textbook, it probably starts to make more sense more quickly than trying to go to the primary source. Those of you that have worked with me in the past know that I'm always encourage you to go to the primary source first, but I'll make this the exception because the process can be a bit tricky when you're trying to work it through from the legislation. So do have a look at the, we'll go back to the guide, the Environment Protection Biodiversity Conservation Act Environment Assessment Manual, implementing Chapter 4 of the EPBCA. You should find this through the Department of Environment and Energy website, which we'll come to, I think, shortly. All right, so I'll just stop the share again. And again, thanks for your patience as we work through this. So previously, we talked about the Commonwealth's environmental lawmaking ability, and we talked about the way in which the laws can be regulated through the EPBCA. Now, one of the things that you need to consider is that there is a requirement for some degree of consultation. After a proposal is referred to the Environment Minister, the question needs to be determined whether it's a controlled action. Have a look at the EPBCA section 74 in that regard. And the Minister has to determine whether the proposal has a significant impact on the environment. Now, here's a key issue for this. It's actually a question for the subjective determination by the Minister. Almost everything we talk about in law is the objective test. But in this instance, it's the subjective test, and the Minister, of course, has a great deal of power to subjectively determine whether this particular proposal before him or her is a proposal that has significant impact on the environment. So the Minister decides whether it's controlled or not, but the Minister must apply the correct test in doing so. I mentioned earlier that the part of the cooperative arrangements is to avoid duplication, and that's done through the bilateral agreement arrangements between the states and the Commonwealth. That's the way in which the duplication for the preparation of multiple environmental assessments is undertaken. And what usually happens is this, that under the cooperative arrangements, under the EPBCA, the matters are normally referred to the state pursuant to the bilateral agreement, and the Commonwealth may be prepared to exempt a proposal from environmental assessment under the EPBCA if it can be satisfactorily dealt with under the state regime. So what it means is that we need to consider state-based environmental assessment primarily relevant to both controlled actions and other development proposals that warrant environmental assessment. So let's have a look at the state-based environmental assessment. There are three key pieces of legislation here at a state level when we're talking about environmental impact assessment. The first is the State Development and Public Works Organisation Act. The second is the Environmental Protection Act, Chapter 3. And the third is the Planning Act. Have a look at Part 2 of Chapter 9. So in each of these, an environmental impact statement is prepared and the bilateral agreement works between the Commonwealth and the states so that we have some avoidance of overlapping. Now, the information about the State Development and Public Works Organisation Act is contained on a website. I'll give that to you shortly, but you'll see that there's a reference to the Coordinator General, and under that Act, the Coordinator General has power to declare a project to be a coordinated project for which environmental impact statement is required. And in doing so, the Coordinator General takes into account a number of factors that are relevant for making that determination. So I'll take you to this website now, Queensland Government, State Development, Manufacturing, Infrastructure and Planning website. And State Development and Public Works Organisation Act commentary. Some commentary there about the role of the Coordinator General could be useful for your second assessment. And you'll see there that the Act gives the Coordinator General significant powers, amongst other things, to manage major infrastructure projects, declare a project to be a coordinated project, coordinate and regulate programs of works, enter and authorise entry onto land to undertake work, compulsorily acquire land, and implement and manage state development areas, as well as other roles which allow the Coordinator General to step in. What I mean by that is where state governments, and local governments and other bodies fail to make a decision on a key point in a timely manner, the Act allows the Coordinator General to, as it were, step in and make the decisions, hurry the process along. So that's a good website for providing you with an overview, a simple overview of the way in which these things work. Now, there's reference there to coordinated projects. So a key role for the Coordinator General is to make a decision as to whether a particular project amounts to a coordinated project. And once again, it falls on the proponent of the project to make a preliminary decision. And the proponent needs to consider whether the project has one or more of a number of characteristics that would or perhaps may apply to have it declared as a coordinated project under the Act. So, for example, if it involves complex approvals or it has potentially significant environmental effects or strategic significance or significant infrastructure requirements, then it may be that the matter will be declared a coordinated project. And it's up to the Coordinator General to give what weight is appropriate to these different factors. But when a project is declared to be coordinated, it triggers the requirements for some rigorous environmental impact assessment. And the proponent then needs to prepare the environmental impact statement or the impact assessment report rather, as a result of the environmental impact assessment requirement. Now, when the coordinated project is undergoing an environmental impact assessment, it does suspend, as we saw earlier, development approvals under the Planning Act or approval processes under the other relevant acts. So this takes priority in that sense. The Coordinator General needs to take into account a number of things in making a declaration decision: detailed information about the project, relevant planning schemes, relevant state policies, feasibility assessments of the project, the capacity of the proponent to undertake and complete the work, and other matters. Let's move on to a different page now. There is a page that provides some more detail in relation to the role and responsibilities of the Coordinator General, again on the same website. And you'll see that it's specific to the State Development and Public Works Organisation Act. Now let's have a look at some current projects. Again, on the same Queensland Government website, we have current projects. And these are projects that are coordinated projects currently going through the environmental impact assessment process. And relevant to the second assessment, you'll see that the Townsville Port Expansion project, which was there, is no longer listed. So when it comes to talking about the current status, well, you may have formed an opinion. I'd go and have a look in the section that deals with completed projects in that regard. The projects that are currently being considered, you will see, are at different stages. And usually there's a reference there to a draft EIS being prepared by the proponent, and that can take some time. Otherwise, it may be that the Coordinator General has accepted the draft EIS and the final EIS is now being prepared, or it may be that the draft terms of reference for the EIS are being prepared. So different projects, of course, are at different stages, and the idea is to identify where things are at. So for the Townsville Port Expansion project, you might be able to identify some historic progression of how the project went through that system. I'll just stop the share. Okay. Question from Sarah, am I going to show the coordinated project process flowchart? I'm not sure that I have it handy.
It's on the website you were just on.
What was that, just on that website?
Yeah, it is on that website. I bumped into it when I was browsing around for the second
Oh,
assessment.
good. Okay, so you found it. All right. Thank you.
I have another quick question with regards to the second assessment that I was working on it today. The second part we're looking at is looking at the steps to the approval process. I just wanted to double check. Am I supposed to be looking at the steps from the position of what the proponents had to do, or the considerations that the Coordinator General and the Minister for Environment do in considering for it? Because those are two different sort of things. Like, obviously the Coordinator General determines whether it needs an IAS, if it's EIS, and then the Minister determines whether it's a controlled action and stuff like that. Do I need to do anything beyond mentioning that?
And this is the hard part with the word count, trying to incorporate both. But ideally, you would incorporate both in that regard.
Okay, cool.
I forget the exact question, but I think it is both. So. I hope that answers it.
Yes, thank you.
Thank you. All right, so I mentioned that in Queensland there are 3 key pieces of legislation. The second one is now the Environmental Protection Act. So in that regard, have a look at section 40 of the Act, and you'll see that it sets out the process or the purposes of an environmental impact statement and the process. So in that section, you'll see there are 6 critical functions. Why do we need the environmental impact statement under the EPA? Well, it assesses both the good and the bad to the environment, to the economic and the social impacts of a particular development. So it's meant to be a balancing act. It's a bit like an expert report or presented in court by an expert, where it's meant to be balanced. That's number 1. Number 2, it proposes how to minimise adverse environmental impacts. Number 3, it considers feasible alternate ways of carrying out the project. Number 4, it provides information for interested parties, including the public. Number 5, it's a catalyst for an environmental management plan. And number 6, it helps regulators to make informed decisions. So before a major project can be given an environmental authority, the EPA requires the determination of the likely environmental impacts, that they need to be assessed, and determination as to how they can be minimised. So major mining and petroleum projects, for example, need to go through an environmental impact statement process. And let's have a look at a website that kind of gives more detail to that statement. So this is state government now, particularly under the Environmental Protection Act, and Queensland government. We're looking at environmental and pollution management, the EIS process. Information there about the EIS process, projects, including current projects, resources might be useful, and the EPBCA bilateral agreement information that we talked about between the Commonwealth and the state of Queensland in this instance. So that's the www.qld.gov.au/environment/pollution/management/EIS-process. So there is a risk under a regulatory strategy that impacts arising from a proposal may result in processes that are environmentally inappropriate. And the EIS, the EIA, is designed to assist in that regard. I'll just change the screen now to give you an example of an environmental impact statement. And this was the Baralabar North project. And you can see that it was an EIS. It was actually prepared in order to comply with the requirements of both the EPBCA and the EPA and the relevant regulations that go with it. So I'd recommend that you look at that, because it just gives you a guide as to how the legislation works in a practical sense. And again, unlike my usual philosophy, I'd recommend you look at this first and then refer it back to the legislation to get a better idea of how it all fits together. And I hope that makes sense. So the third matter, or the third piece of key legislation in Queensland, is the Planning Act 2016, formerly the Sustainable Planning Act 2009. So under the Planning Act 2016, environmental impact assessment does not depend on a discretionary analysis of potential impacts, but under the Planning Act, we need to consider firstly a threshold question. So because under the Planning Act, there are three types of developments. Essentially, that which is prohibited, that which is accepted, and thirdly, that which is accessible. So of course, we're really talking about the third here, that which is accessible, where someone needs to make a decision. Some are prohibited, some are accepted without question. The big part, the meaty part, that which is accessible. Now, within the regime of accessible, we've got impact and code assessment. I'd recommend that you have a look at a website. The one that I've selected is actually the Department of Environment and Science. It relates specifically to wetland information, Queensland Government, but it has a really good overview of how impact assessment works under the Planning Act. And I'll just share the screen now. So this is wetland.des.qld.gov.au/wetlands/legislation-update/impact-assessment. And you'll see there the commentary about the Planning Act, the types of development, and the two types of accessible development, impact and code. It also then provides some information about impact assessment in particular. And what I like about this website is it sets out really neat, in a very neat fashion, the way in which this regime works involving the Commonwealth and of course the EPBCA. It sets out the assessment mechanism, recognition of matters of national environmental significance. And then it goes on to talk about state-based matters in terms of environmental impact statements and the way in which it works under the Environment Protection Act. It has also reference to the Development Assessing Mapping System, which is very useful, and there's links to these things as well. The next part relates to coordinated projects under the State Development and Public Works Organisation Act, and essentially that's a very neat summary of what we've discussed tonight already in that area. Then goes on to talk about the marine parks, nature conservation, and it includes these mechanisms and resources further available, as well as a link to the relevant legislation. All right, so I'd commend that to you. One of the things that you've seen is that when we're talking about the Coordinator General, coming back to the State Works and Public Organisation Act, there's a question as to whether we're dealing with a coordinated project or not, which is a threshold question as to whether or not there is a requirement for an EIS. And also you'll see that there's the references I mentioned to the Marine Parks Act and the Nature Conservation Act, which you may need to consider. We're almost done for this evening, so thank you for your patience. But there is one other piece of legislation I want you to consider in the context of your discussions, and that is the Strong and Sustainable Resource Communities Act 2017. So I'm going to share with you a link to a fact sheet that might be useful in relation to this matter. This is from the state government, and it provides an overview of what is meant by this legislation. It was introduced in 2016 in November, has now become an act. The bill was passed in 2017 with assent in 2017. And the idea of this legislation is to provide ways in which residents of communities in the vicinity of large resource projects may have a say, and the objects ensure that the residents in the vicinity of those projects can benefit from the construction and operation of the projects, and this object is achieved as a result of, let's see if we've got the next page. This is achieved as a result of, I'll just go to section 3, which will actually show us. Yep, there it is. So it's achieved by the preparation of social impact assessment, which is relevant for what we're discussing tonight, to employ people in nearby communities and not to discriminate. So that's another source of information about and requirement to have environmental impact statements. Oh, you've been really patient tonight. I know I've talked a lot, I'm sorry, but you've done very well. As I said, we're about to wrap up, but before I do, are there any questions, comments? All good? All right. While we're thinking about that, next week, week 8, we're dealing with protection of biodiversity and climate change. So I won't be here for the live session on Tuesday, the 14th of January. My apologies for that, but I will upload the week 8 material and you'll see that on Moodle. Please feel free to go online yourselves next week. Climate change hot topic right now, I know, it's a bit scary. And we'll look forward to seeing you in the live session in 2 weeks from tonight. So that would be the 27th, no? I'll just have to check my calendar for that. Sorry. To the 21st, of course. So 2 weeks tonight, the 21st of January is when we'll be dealing with week 9 material. So week 8, I'll upload, and we'll see you on Tuesday the 21st. So all the best and good luck with your assessments. Bye then.
Thank you.